Okay, so this is actually a re-recording of this chapter because I was robbed because it said on my phone that uh, this file had been uploaded, this audio file had been uploaded to Google Drive. It was showing up on my phone as in Google Drive, but then I went to edit the video and edit in the loosest possible use of that word. Uh, the files weren't there, and I'd already removed them from my phone because I'm chronically running out of space because I'm recording shit and taking videos of myself walking around shirtless. So I deleted it, and I shouldn't have deleted it, so I have to re-record it again. So I apologize if this reading is sketchy or rushed or anything like that, but I'm reading angry. so, so bear with me. Introduction. The tasks of general legal theory. The general theory of law may be defined as the development of the most fundamental and abstract juridical concepts such as, quote, legal norm, quote, legal relation, quote, legal subject, and so on. Since these concepts are abstract, they are applicable to each and every branch of law regardless of the concrete content to which they are applied. Their logical and systematic meaning remains constant. No one would dispute the fact that the concept of the subject in civil law or in international law is subordinate to the more general concept of the legal subject as such, so that the latter category may be defined and developed independently of either concrete content. Alternatively, if we confine ourselves to one particular branch of law, we can still establish that the fundamental juridical categories cited above are not dependent on the concrete content of its legal norms, in the sense that they retain their meaning irrespective of any change in this concrete material content. Obviously, these most abstract and simple juridical concepts result from a logical elaboration of the norms of positive law, and, as compared with spontaneously arising legal relations and the norms which express these, they represent the late ripening fruit of a conscious process of creation. Nevertheless, this does not prevent the philosophers of the Neo-Kantian school from regarding the fundamental juridical categories as prior to experience, rendering experience itself possible. Thus we read in Savalsky, for example, quote, subject-object relation and law of relation are the a priori of legal experience, its immutable logical premises, end quote. And further, quote, the legal relation is the only ineluctable condition of all legal institutions, and thus it follows of jurisprudence too, for without the legal relation there can be no related science, that is, no jurisprudence, just as nature and hence natural science cannot subsist without the principle of causality. End quote. In his observations, Savalsky is merely restating the conclusions reached by Cohen, one of the most prominent Neo-Kantians. We find the same viewpoint produced by Stalmer in his earlier fundamental work, Economy and Law, as well as in his last work, Textbook on Legal Philosophy. In the latter we read, quote, amongst the concept of law, one must differentiate between pure and qualified juridical concepts. The former are the general formulations of the fundamental principles of law. For the pure juridical concepts to be applied, nothing more is required than the notion of law itself. The pure juridical concepts, therefore, have application across the board to all legal questions which could conceivably arise. For the pure juridical concepts are nothing other than various manifestations of the formal concepts of law. For this reason, pure juridical concepts should be derived from fixed definitions of that concept. I think that concept being the formal concept of law. End quote. Stalmer. Jesus Christ, I was saying his name wrong. Stalmer. However fervently the Neo-Kantians may assure us that in their view the, quote, idea of law, end quote, precedes experience not genetically, in time, but logically and epistemologically, we must insist that so-called critical philosophy leads us on this, as on many other points, back to medieval scholasticism. It can thus be taken as axiomatic that developed juridical thought cannot do without a certain number of the most abstract general definitions, irrespective of the subject with which it is dealing. Nor can Soviet jurisprudence do without such abstract definitions if Soviet jurisprudence is to remain a jurisprudence, that is, if Soviet jurisprudence is to be equal to Soviet jurisprudence's immediate practical task. The fundamental or formal juridical concepts have a continued existence in our statute books and corresponding commentaries. Also still with us is the method of juridical thought with the procedures peculiar to the method of juridical thought. But does this prove that the scientific theory of law should be concerned with the analysis of the above-mentioned abstractions? There is a fairly widely held view that these most general juridical concepts have a limited and purely technical relevance. We are told that dogmatic jurisprudence uses these terms for reasons of convenience alone. They have, supposedly, no further significance for theory and epistemology. Yet the fact that dogmatic jurisprudence is a practical and, in a certain sense, technical discipline does not warrant the conclusion that the concepts of this jurisprudence could not form part of a related theoretical discipline. We agree with Karl Renner when he asserts that the science of law begins where jurisprudence ends. It does not follow from this that the science of law begins where jurisprudence ends, that legal science should simply throw overboard the basic abstractions which give expression to the fundamental essence of the legal form. After all, political economy too began political economy's development with practical questions, mainly in the sphere of the circulation of money. Political economy also first set itself the task of establishing, quote, the means of enriching governments and the people, end quote. Nonetheless, even in these technical deliberations, one can see the foundations of those concepts which have been absorbed in a deeper and more general form into the body of the theoretical discipline of political economy. Can jurisprudence be developed into a general theory of law without disintegrating into either psychology or sociology in the process? Is it possible to analyze the fundamental definitions of the legal form in the same way as political economy analyzes the basic, most general definitions of the commodity form or the value form? Whether or not the general theory of law can be regarded as an independent theoretical discipline is dependent upon these questions being resolved. Bourgeois legal theory, whose representatives in the main are of a neo-Kantian persuasion, resolves the problem cited above by a simple opposition of two categories, the category of is and the category of ought. In accordance with this, the Neo-Kantians postulate two very different scientific viewpoints, the explicative and the normative. Quote, the explicative approach is concerned with things as they really actually are, which the explicative approach attempts to render more intelligible by linking either things' inner similarities or those congruities suggested by things' external characteristics. The normative approach considers objects in the light of fixed laws which are expressed through them, and simultaneously applies these laws as requirements to each individual object. In the explicative view, therefore, all facts as such are taken to have equal validity, while in the normative approach, facts are consistently subjected to an evaluation, either by abstracting from whatever conflicts with the laws which have been postulated, or by contrasting it as behavior outside the norm to normal behavior which substantiates the law, end quote. In Zimmel, the category of ought determines a particular way of thinking, which is separated from an unbridgeable abyss, from that logical order wherein we conceive of the is running its course with natural necessity. The concrete, quote, thou shalt, end quote, can be substantiated only by reference to a further imperative. It is not possible within the bounds of logic to infer the imperative from necessity, nor vice versa. In his most important work, Economy and Law, Stammler plays innumerable variations on this theme, namely the notion that the order of things can be determined by two different methods, the causal and the teleological. Thus jurisprudence would seem to have acquired a firm methodological basis as one of the normative disciplines. Indeed, the attempts to give this methodology some depth led Kelsen, for one, to the conviction that jurisprudence especially is an essentially normative science, since jurisprudence may be restricted more readily than any other discipline of jurisprudence's kind to the confines of the formal, logical sense of the category of ought. It is true that the normative is saturated with psychological elements, both in ethics and in both in ethics and in aesthetics, so that it can be considered as qualified volition, that is, as a given fact, as an is. The standpoint of causality continually obtrudes upon and detracts from the purity of the normative interpretation. As opposed to this, the imperative principle occurs in law, whose highest expression, according to Kelsen, is the law of the state, in a categorical heteronomous form, from which has definitively broken with the factual, with that which is. All that remains is to transfer the legislative function itself to the meta-juridical sphere, as Kelsen does, and all that jurisprudence has left is the pure sphere of the normative. Jurisprudence's task is confined exclusively to ordering the various normative contents in a logically determined manner. Unquestionably, one must give Kelsen credit for one great service. As a result of his undaunted consistency, Kelsen reduced neo-Kantian methodology, with Kantian methodology's two categories, to absurdity. For it turns out that the, quote, pure, end quote, category of ought, cleansed of all impurities from the is, or the factual, and of all psychological and sociological, quote, dross, end quote, neither has nor possibly can have any rational definition whatsoever. Purpose itself is immaterial, a matter of indifference, to the purely juridical, that is, to the unconditionally heteronomous ought. According to Kelsen, even the formulation, quote, thou shalt, in order that, end quote, is no longer the same as the juridical, quote, thou shalt, end quote. On the plane of the juridical ought, there is nothing but a transition from one norm to another on the rungs of a hierarchical ladder, at the top of which is the all-embracing supreme norm-setting authority, a delimiting concept from which jurisprudence proceeds as from something given. One of Kelsen's critics has illustrated this attitude to the tasks of jurisprudence in the form of a caricatured conversation between a jurist and a legislator, as follows, quote, we neither know nor care what kind of laws you should make. That appertains to the art of legislation, which is foreign to us. Pass laws as you wish. Once you have passed those laws, we shall explain to you in Latin what kind of a law you have passed. End quote. End quote. Such a general theory of law explains nothing, and turns its back from the outset on the facts of reality, that is, of social life, busying itself with norms without being in the least interested in their origin, a meta-juridical question, or in the norm's relationship to any material matters. Surely this can lay claim to the title of a theory, at best, only in the sense that it is common practice to speak of a theory of chess. A theory of this nature has nothing to do with science. This, quote, theory, end quote, makes not the slightest attempt to analyze law, the legal form, as a historical form. For this, quote, theory, end quote, has absolutely no intention of fathoming reality. For this reason, this, quote, theory, end quote, is, to put it bluntly, a waste of time. The so-called sociological and psychological theories of law are different. One is entitled to expect more of these theories, since by means of the methods sociological and psychological theories of law use, sociological and psychological theories of law undertake to interpret law as a real phenomenon in law's origin and development. But here a new disappointment awaits us. The sociological and psychological theories of law usually exclude the legal form as such from the psychological and sociological theories of law's field of observation. In other words, the sociological and psychological theories of law simply overlook the problem involved in it. They operate from the outset with concepts of non-juridical nature, of a non-juridical nature. And even when they do occasionally take purely juridical definitions into consideration, the sociological and psychological theories of law do so merely in order to label them, quote, fictions, end quote, quote, ideological illusions, end quote, quote, projections, end quote, and so on. This naturalistic or nihilistic attitude has a certain appeal at first sight, particularly when contrasted with the idealist theories of law, which are saturated through and through with teleology and, quote, moralism, end quote. After the high-sounding phrases about the, quote, eternal idea of law, end quote, or the, quote, absolute significance of the personality, end quote, the reader who is looking for a materialist explanation of social phenomenon will turn with particular satisfaction to theories which treat law as the product of conflict of interest, as the manifestation of state coercion, or even as a process which takes place in the actual human psyche. Many Marxists assumed that by simply adding in the element of class struggle, and I gotta save the file of the other recording that I had to redo. 1 second. Let's hope fucking Adobe Acrobat doesn't fucking crash. Come on, you bitch. Alright, it didn't crash. Now I gotta remember where I was. I'm not sure if this is where I was at, but this naturalistic or nihilistic attitude has a certain appeal at first sight, particularly when contrasted with the idealist theories of law, which are saturated through and through with teleology and, quote, moralism, end quote. After the high-sounding phrases about the, quote, eternal idea of law, end quote, or the, quote, absolute significance of the personality, end quote, the reader who is looking for a materialist explanation of social phenomenon will turn with particular satisfaction to theories which treat law as the product of conflict of interest, as the manifestation of state coercion, or even as a process which takes place in the actual human psyche. Many Marxists assume that by simply adding in the element of class struggle to the above-mentioned theories, those Marxists would attain a purely materialist Marxist theory of law. Yet all that follows from this is a history of economic systems with a fairly faint juridical tinge, or a history of institutions, but by no means a history of law. While those bourgeois jurists, such as Glumpovich, who were trying to champion materialist views in some degree, felt bound to examine closely, as it were ex officio, the arsenal of fundamental juridical concepts, even if only to declare them to be artificial formal constructs. Marxists, on the other hand, who have no responsibility towards jurisprudence, usually pass over the formal definitions of general legal theory in silence and devote their undivided attention to the concrete content of the legal norms and the historical development of legal institutions. Indeed, it needs saying at this point that when Marxist authors speak of juridical concepts, Marxist authors are usually thinking of the legal regulation specific to any one epoch. In other words, those Marxist authors are thinking of that which people at a given stage of development look upon as law. This is evident, for example, in the following formulation. Quote, on the basis of a particular state of the productive forces, there come into existence certain relations of production which receive those relations of production's ideal expression in the legal notion of men and in more or less, quote, abstract rules, end quote, in unwritten customs and written laws, end quote. That's Plekhanov. Here the concept of law is examined exclusively from the point of view of its content. The question of the legal form as such is not raised at all. Nevertheless, there is no doubt but that Marxist theory should not only analyze the material content of legal regulation in different historical epochs, but should also provide a materialist interpretation of legal regulation as a specific historical form. If, however, we forego an analysis of the fundamental juridical concepts, all we get is a theory which explains the emergence of legal regulation from the material needs of society, and thus provides an explanation of the fact that legal norms conform to the material interest of particular social classes. Yet legal regulation itself has still not been analyzed as a form, despite the wealth of historical content with which we imbue it. Instead of being able to avail ourselves of an abundance of internal structures and interconnections of the juridical, we are forced to make do with its bare outlines, only approximately indicated. These outlines are so blurred that the borderline between the sphere of the juridical and adjacent spheres is completely obliterated. It must be acknowledged that it is legitimate up to a point to proceed in this manner. Economic history can be described without any mention whatsoever, for instance, of the theory of rent or wage theory. But what would we think of an economic historian who allowed the fundamental categories of political economy, such as value, capital, rent, profit, to be submerged into the vague, undifferentiated concept of economics, not to speak of the reception with which any attempt to pass off such economic history as a theory of political economy would be greeted? Nonetheless, this is exactly how matters stand at present with Marxist legal theory. To be sure, there is some comfort in the fact that the jurists are still searching in vain for a definition of their concept of law. Even if most lectures on general legal theory usually begin with some formula or other, actually this formula provides at best only an unclear, unarticulated approximation of the juridical. It can be postulated as axiomatic that we learn very little indeed about what law really is from the definitions law is given It can be postulated as axiomatic that we learn very little indeed about what law really is from the definitions law is given, and, conversely, that the less an academic clings to his own definition of law, the more likely that academic is to succeed in making us familiar with law as a form. The cause of this state of affairs is quite obvious. A concept as complex as that of law cannot be fully comprehended within a definition formulated according to the rules of scholastic logic, per genus et per differentium specificum. Regrettably, those few Marxists who are concerned with the theory of law have fallen prey to the temptations of scholastic wisdom. Thus, Renner, for example, based his definition of law on the concept of an imperative addressed to the individual by society. He assumes that this somewhat unimaginative construct is adequate to the task of exploring the past, present, and future of legal institutions. The fundamental shortcoming of such formulae is their inability to comprehend the concept of law in the concept of law's actual workings, which expose the whole wealth of its internal connections and correlations, instead of presenting us with the concept of law in its most distinct and consummate form, thereby demonstrating the concept of law's relevance to a particular historical epoch. They serve up an empty platitude about, quote, external authoritarian regulation, end quote, which applies equally to all epochs and all stages of social development. There is an exact analogy in political economy, in the attempts to find a definition of the concept of economics which would encompass all historical epochs. If the whole of economic theory consisted of such sterile scholastic generalizations, it would scarcely merit being called a science. As we well know, Marx begins his investigation not with observations about the economy in general, but with an analysis of the commodity and of value, for the economy only begins to be differentiated as a distinct sphere of relations with the emergence of exchange. So long as there are no relations determined by value, it is difficult to distinguish economic activity from the remaining totality of life's activities, together with which it forms a synthetic whole. Pure natural economy cannot form the subject of political economy as an autonomous science. The relations of capitalist commodity production alone form the subject matter of political economy as an independent theoretical discipline employing its own specific concepts. Quote, political economy begins with commodities, begins from the moment when products are exchanged for one another, whether by individuals or by primitive communities, end quote. Engels. That's an Engels quote. Just a side note, that's a very disputed claim that Engels just made. There's a video on my channel by Chris Author about the myth of simple commodity production, which is kind of what Engels seems to be alluding to here, as if the law of value is present in arbitrary acts of exchange, or even when market imperatives are merely accidental occurrences of people exchanging, independent producers, self-sustaining independent producers exchange their surplus for various things they might need or enjoy. There's a whole thing of whether the description of commodities that's provided in Volume 1 of Capital is a historical analysis that applies to anywhere where any commodity may be applied, or specifically a capitalistically produced commodity. And it seems like Engels here, and I think that is in fact what Engels is doing here, is saying that political economy is applicable to any situation where someone trades something, which I think a lot of people would say is inconsistent with Marx's overall critique of political economy, and is incoherent, but and historically non-demonstrable. Anyway, sorry, I don't know what I'm talking. Anyway, the same applies without reservation to the general theory of law. These basic juridical abstractions, presenting the closest approximations to the legal form as such, which are generated in the course of the development of juridical thought, reflect quite specific, very complex social relations. Any attempt to discover a definition of law corresponding not only to these complex relations, but also to, quote, human nature, end quote, or to the, quote, human commonwealth, end quote, must inevitably result in empty scholastic verbal formulae. When one is then forced to then turn from this lifeless formula to the analysis of the legal form, as the legal form actually occurs, one encounters a series of obstacles. These obstacles can be overcome one by way of notorious stratagems. Hence we are told, but usually only after having first been given a general definition of law, that there are actually two kinds of law, subjective and objective law, jus agendi and norma agendi. The problem with this is that the definition itself in no way admits of such a dichotomy, so that one is forced either to negate one of these of two kinds of law, presenting that kind of law as fictitious, illusory, and so forth, or to assume a purely superficial connection between the general concept of law and its two forms. Nonetheless, this dual nature of law's split into norm and legal power, is of similarly vital significance, as is, for example, the split of the commodity into use value and exchange value. Law as a form is comprehensible only within its most precise definitions. Law exists only in antithesis. Objective law, subjective law, public law, private law, and so on. Yet all these fundamental distinctions will turn out to be mechanistically appended to the basic formula if we expect this to span all epochs and stages of social development, even including those which knew absolutely nothing about the antithesis cited above. It is only with the advent of bourgeois capitalist society that all the necessary conditions are created for the juridical factor to attain complete distinctness in social relations. Leaving aside altogether the culture of primitive peoples, in which it is difficult to distinguish law from the total mass of normative social phenomenon, one finds that even in medieval Europe only embryonic legal forms existed. All the antitheses mentioned above fuse into an undifferentiated whole. There is no clear dividing line between law as objective norm and law as legal power. They make no distinction between the general norm and the general norm's concrete application. As a result, the spheres of activity of judge and legislator are indistinguishable, both in the Mark community and in the organization of the feudal system, the antithesis between public and private law is obliterated. The opposition of man as a private person to man as a member of a political grouping, so typical of the bourgeois epoch, is completely absent. A long process of development was necessary for all these facets of the legal form to become crystallized with complete precision. The cities were the most important stage upon which this process was acted out. Therefore, the dialectical development of the fundamental juridical concepts can only provide us with the legal form as a fully developed and articulated structure, but also reflects the actual process of historical development, a process which is synonymous with the process of development of bourgeois society itself. The objection that, as a discipline, the general theory of law deals only with formal qualified definitions and artificial constructs cannot be raised against our interpretation of it. There is no doubt that political economy studies something which actually exists, even though Marx himself was the first to point out that in the discovery of entities like value, capital, profit, rent, and so forth, quote, neither microscopes nor chemical reagents are of assistance, end quote. The theory of law makes use of abstractions which are no less, quote, artificial, end quote. The research methods of natural science cannot discover a, quote, legal relation, end quote, or a, quote, legal subject, end quote, either, yet behind these abstractions, too, lie perfectly real social forces. To a person living in a natural economy, the economics of value relations would appear as an artificial distortion of simple natural things, in just the same way as the legal turn of mind appears to run counter to the, quote, common sense, end quote, of the ordinary person. It is worth noting that the, quote, ordinary person, end quote, is mentally far less accustomed to the legal than to the economic viewpoint. For even in a situation where the economic relation simultaneously materializes as a legal relation, in the overwhelming majority of cases, it is the economic aspect of it which really interests the participants, whilst the juridical aspect remains in the background, becoming fully exposed to view only in exceptional cases, trial, litigation. Further, the people who personify the, quote, juridical aspect, end quote, in its sphere of activity are generally members of a particular caste, lawyers, judges. That is why ordinary people are more used to thinking in economic categories and find this more natural than thinking in juridical categories. To think that the juridical concepts which express the sense of the legal form have been quite arbitrarily dreamt up is to fall into the error which Marx pointed to in the work of the Enlightenment scholars of the 18th century. According to Marx, these scholars were still unable to account for the origin and development of the enigmatic forms assumed by human relations, so they tried to render these forms less incomprehensible by declaring them to be, in fact, human inventions, rather than something which appeared out of the blue. However, it cannot be denied that a large number of juridical constructs, most of the constructs of public law, for example, are really extraordinarily arbitrary and questionable. We shall try, in what follows, to elucidate the reasons for this. For the time being, we shall confine ourselves to the observation that the value form becomes universal under the conditions of developed commodity production and assumes, besides its primary forms, various derived and artificial forms of expression. Thus, it appears as the price of things which are not the products of labor, such as land, or even of things which have absolutely nothing to do with the production process. For instance, military secrets purchased by a spy. Nevertheless, this does not alter the fact that value as an economic category can be comprehended only from the standpoint of the socially necessary expenditure of labor required in the production of a given commodity. In the same way, the universality of the legal form does not necessarily call a halt to our search for these relations on which it is actually based. Later, we hope to be able to establish that this basis is not synonymous with those relations known as public law relations. A further objection to our conception of the tasks of general legal theory is that the underlying abstractions are regarded as exclusive to bourgeois law. Proletarian law, we are told, should find alternative general concepts, and the search for such alternatives should be the task of the Marxist theory of law. At first sight, this objection appears to be a very serious objection. Yet this objection rests on a misunderstanding. In raising a demand for new general concepts specific to proletarian law, this line appears to be revolutionary par excellence. In reality, however, this tendency proclaims the immortality of the legal form, in that it strives to wrench this form from the particular historical conditions which had helped bring it to full fruition, and to present it as capable of permanent renewal. The withering away of certain categories of bourgeois law, the categories as such, not this or that precept, in no way implies their replacement by new categories of proletarian law, just as the withering away of the categories of value, capital, profit, and so forth in the transition to fully developed socialism will not mean the emergence of new proletarian categories of value, capital, and so on. The withering away of the categories of bourgeois law will, under these conditions, mean the withering away of law altogether, that is to say, the disappearance of the juridical factor from social relations. Excuse me. It was like fighting a burp there. The transition period, as Marx showed in his critique of the Gotha program, is characterized by the fact that social relations will, for a time, necessarily continue to be constrained by the, quote, narrow horizon of bourgeois right, end quote. It is interesting to analyze what constitutes, in Marx's view, this narrow horizon of bourgeois right. Marx presupposes a social order in which the means of production are socially owned and in which the producers do not exchange their products. Consequently, he assumes a higher stage of development, that the, quote, new economic policy, end quote, which we are presently experiencing. He sees the market as having been already replaced by an organized framework such that in no way, quote, does the labor employed in the products appear here as the value of these products, as a material quality possessed by them, since for now, in contrast to capitalist society, individual labor no longer exists in an indirect fashion, but directly as a component part of the total labor, end quote. Critique of the Gotha program. Nevertheless, Marx says, even when the market and market exchange have been completely abolished, the new communist society will of necessity be, quote, in every respect, economically, morally, and intellectually, still stamped with the birthmarks of the old society from whose womb it emerges, end quote. Critique of the Gotha program. This becomes evident in the principle of distribution as well, according to which, quote, the individual producer receives back from society after the deductions have been made exactly what he gives to it, end quote. Critique of the Gotha program. Marx stresses that in spite of the radical transformation of form and content, quote, the same principle prevails as that which regulates the exchange of commodities, as far as this exchange of equal values, a given amount of labor in one form is exchanged for an equal amount of labor in another form, end quote. Critique of the Gotha program. To the extent that the relation of the individual producer to society still retains the form of the exchange of equivalents, it also retains the form of law, recht, for right. By its very nature, can consist only in the application of an equal standard. Wait, was there a quote here? Sorry. Sometimes when you're reading something, there'll be like a quotation mark, and it looks like it just ended, but I'm not looking back up through the text, so I'm not finding like an initiating quotation mark, so I think that might be a typo. Anyway, let me reread that sentence. To the extent that the relation of the individual producer to society still retains the form of the exchange of equivalents, it also retains the form of law, for, quote, right, end quote, by its very nature, can consist only in the application of an equal standard. However, as this makes no allowance for the natural inequality of individual talent, it is, quote, a right of inequality in its content like every right, end quote. Marx does not mention that there must be a state authority which guarantees the enforcement of these norms of, quote, unequal, end quote, right, by its coercion, thus retaining its, quote, bourgeois limit, end quote, but that goes without saying. Lenin concludes, quote, of course, bourgeois right in regard to the distribution of consumer goods inevitably presupposes the existence of the bourgeois state, for right is nothing without an apparatus capable of enforcing the observance of the standards of right. It follows that under communism there remains for a time not only bourgeois right, but even the bourgeois state without the bourgeoisie, end quote. Lenin. It's probably State and Revolution, let's see. Yeah, that's State and Revolution. Once the form of equivalent exchange is given, then the form of law, the form of public or state authority, is also given, and consequently this form persists even after the class structure has ceased to exist. The withering away of law, and with it of the state, ensues, in Marx's view, only after, quote, labor has become not only a means of life, but life's prime want, end quote. Marginal notes. Marx. When the productive forces grow together with the all-round development of the individual, when everyone works spontaneously according to their abilities, or as Lenin puts it, when one will no longer be forced to, quote, calculate with the heartlessness of a Shylock whether one has not worked half an hour more than somebody else, end quote. In a word, when the form of the equivalent relation has been finally dispensed with. Thus, Marx conceives of the transition to developed communism not as a transition to new forms of law, but as a withering away of the legal form as such, as a liberation from that heritage of the bourgeois epoch which is fated to outlive the bourgeoisie itself. At the same time, Marx reveals that the fundamental condition of existence of the legal form is rooted in the very economic organization of society. In other words, the existence of the legal form is contingent upon the integration of the different products of labor, according to the principle of equivalent exchange. In so doing, he exposes the deep interconnection between the legal form and the commodity form. Any such society which is constrained by the level of development of that society's productive forces to retain an equivalent relation between expenditure and compensation of labor in a form which even remotely suggests the exchange of commodity values will be compelled to retain the legal form as well. Only by starting from this fundamental aspect can one understand why a whole series of other social relations assume legal form. To draw the inference from this, however, that there must always be laws and courts, since not even with the greatest possible economic provision would there be an end to all offenses against the person, would simply mean taking secondary minor aspects of the main fundamental ones, for the main fundamental ones, fundamental aspects. Even progressive bourgeois criminology has become convinced that the prevention of crime may properly be viewed as a medical educational problem. To view this problem, jurists with their, quote, evidence, end quote, their codes, their concepts of, quote, guilt, end quote, and of, quote, full or diminished responsibility, end quote, or their fine distinction between complicity, aiding and abetting, investigation, and so on, are entirely superfluous. And the only reason this theoretical conviction has not yet led to the abolition of penal codes in criminal courts is, of course, that the overthrow of the legal form is dependent not only on transcending the framework of bourgeois society, but also on a radical emancipation from all its remnants. The critique of bourgeois jurisprudence from the standpoint of scientific socialism must follow the example of Marx's critique of bourgeois political economy. For that purpose, this critique must, above all, venture into enemy territory. It should not throw aside the generalizations and abstractions elaborated by bourgeois jurists, whose starting point was the needs of their class and of their times. Rather, by analyzing these abstract categories, it should demonstrate their true significance and lay bare the historically limited nature of the legal form. Every ideology dies together with the social relations which produced that ideology. This final disappearance is, however, preceded by a moment when the ideology, suffering the blows of the critique directed at it, loses its ability to veil and conceal the social relations from which it emanated. The exposure of the roots of an ideology is a sure sign of that ideology's imminent end. For, as Lassalle said, quote, the dawning of a new age always consists only in the knowledge attained about the true nature of the preceding reality, end quote. Lassalle. Well, we got through that introduction, and I'm going to tell you that I'm very relieved because I've been sitting on this entire book, and I've been grumpily refusing to reread the sections that I lost on the internet, or not on the internet, to Google Drive's shenanigans, and now I've completed the rereadings that I wanted to, and I'm very proud of myself, so I congratulate myself on being wonderful. So wonderful.